Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. So today's topic is going to be about how do we revoke a will. But before we dive into this topic, if you have any questions pertaining to estate planning or probate and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com right now and schedule a day and time that works best for you. So how do we revoke a will? The normal concept, but it is a huge misconception and a huge fallacy, is, and I see this every day, is people think they can take their will and honestly just, take it, paragraph, scribble it out, cross it out, white it out, initial and sign, and they're covered. That doesn't work. That's not effective. There are 3 ways in the state of New Jersey to properly revoke a will. We'll talk about changing wills at a later date, but how to revoke a will properly, is there are 3 ways. And the first way is really to, the first way that I recommend doing it is destroy your will. Destruction of the will is number 1, the number 1 way to do it. And what do I mean by this? It has to be the intent of the creator. So you have a will, you take it, you destroy it. You have to have that intention. And what do I mean by that? Ripping up your will, setting it on fire, is destroying it. Clear and simple. There was an intent to not have it anymore. Putting it in the shredder, there's an intent. You can even leave a letter after it with the shredded pieces or the lit up pieces and say, I revoked this will. It was my intent to get rid of this. And you sign that letter and have it witnessed. There's your intent. You've revoked that will. Destruction. Number 2, but hold on. Before we dive into number 2, when destruction, we have a caveat. Sometimes it isn't our intent to destroy a will because our will's been destroyed for a natural reason. And what do I mean by this natural reason? I mean that the will, you lost it in a flood, your house burned down, you lost it in a move. Scenarios like this where it was never your intent to destroy your will, but your will got destroyed in the process. So what do? So attorneys hold on to copies called certified true copies, and when you go to probate, the attorney can submit this copy and say, look, with a letter to the court and to the surrogate's court saying the person lost their original due to this circumstance. They moved, they lost their documents, it was the house burnt down on X date. They could never locate their documents. However, here is a certified true copy of their original will, and this is still a valid will. That covers you there. So if you had no intent to destroy your will, you're okay. Don't panic. But if you have an intent to destroy your will, we're good. All right, number 2. A little theatrics right there. You like that? It's something different. But okay, number 2. Is creating a new will. This is how you revoke a previous will. So you're saying, David, I can't have 2 wills. Yes, you can. You can redo your will as many times as you want in your lifetime. Don't let anybody tell you otherwise. So when you draft a will, and probably in your current will right now, it says in the first paragraph after it states who you are, where you reside, and that you are of sound mind, it says that this will revokes any previous wills that may have been created and revokes any other wills up until this date. Cool. So when we make a new will, what I do, at least, is after we execute it, I take your old will, I put it in the shredder, and you get your new will. I've destroyed that one, that was your intent, and you signed a new one. But if you want to keep your old one because you have some sentimental value to it, you just want to make sure nobody, for whatever reason. Some people like to keep their old wills because, you didn't spend money on these things. By signing that new will and having it witnessed and notarized, that allows you, that will supersedes the old will. So we have option 1, which is destruction, option 2, which is creating a new will. And option 3 is the formal way. It's not a way that I see done very often, and it's not a way that I do things I don't actually ever use this option, but it's an option. And option 3 is a letter of revocation. So what this does is basically you are putting on top of your will, it's a letter that says, I am revoking the contents of this will, and this will no longer exists. You're signing it in front of 2 witnesses, and it's being notarized. It's getting stapled to the front of that will, and therefore you have destroyed that will because you've revoked the contents of it. I never use that way because I have some issues with it. If you have a will, why are we just going to revoke it and put it into the state's hands again and go into the rules of intestacy and have to go through administration? Let's just create a new will. Let's destroy a will. So, to summarize this whole video, there are 3 ways to revoke a will: destruction, creating a new will, and a letter of revocation. I hope you found this video informative. If you did, hit that like button. If you know somebody who's going through the estate planning process and has questions about this, may want to update their will, share this video with them. Tell them you were thinking about that. Follow us over to YouTube. Like and subscribe over there. We're also on TikTok and Instagram. I don't know why I keep doing this, but anyway. TikTok and Instagram at NJ Estate Attorney. We're putting out short little quick videos up there as well. We also have a podcast. Go follow us on our podcast. You know, subscribe to us. Make us part of your morning or evening drive. And you can find us at Estate Planning Daily, Estate Planning New Jersey Daily, or New Jersey Estate Planning Daily on all your podcast sources. If you have any questions pertaining to estate planning or probate, or even this topic, and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com right now and schedule a day and time that works best for you. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.